The broadcast is now starting. All attendees are in listen-only mode.
So good afternoon and welcome to the November webinar from 12 Points Wealth Management entitled Essential Legal Documents for Every Family. We're going to get started here in just a moment. We've got people rolling through and the numbers are increasing, so thank you for that. And on the line here, my name is Christopher Cahill. I'm partner in charge of the Family Office Services Group here at 12 Points Wealth Management. And I'm really pleased to have Andrew Butler, partner at Archstone Law Group in Newton, Massachusetts, with me today to help move this conversation along. So Andrew, thanks for joining again.
Thank you, Christopher. Pleasure to be here.
So, you know what, I think that we should try to be respectful of folks' time. We like to try to get in and out of these things within a half hour, maybe 40 minutes max. So let's just start rolling and we'll let other folks catch up. If you have any questions throughout the course of the presentation, people, please just put them in the chat box. We'll do our best to answer them. If not, we'll show you our contact information at the end. By all means, feel free to reach out to either Andrew or myself with any and all questions that you've got. We'll do our best to answer them. And we're really excited about talking about this topic with you that's near and dear to both of our hearts. So with that being said, let me move forward. So as I said, my name's Chris Cahill. I'm an attorney, certified financial planner, and a chartered advisor in philanthropy. I've spent the past 25 years in the world of financial services, working with high net worth clients of all types, many attorneys, business owners, C-suite execs, and I really am passionate about the world of estate planning and business succession and making sure that your values, your goals, and your objectives are met and mirrored through your planning documents. So with that being said, I'm very happy to have Andrew with us again here. So as I said, Andrew's a partner at Archstone Law Group in Newton, Mass. And Andrew, why don't you spend a minute giving a little bit of background on yourself?
Sure, thanks, Chris. So as Chris mentioned, I'm Andrew Butler. I am a partner, or technically a shareholder, with Archstone Law Group. Our office is in Newton, and I've been with Archstone for about 15 years. Prior to that, I had my own practice in the sort of Newton-Wellesley area, and prior to that, I worked at a couple of the bigger firms in downtown Boston. But the one constant throughout my entire career, which actually I probably need to update this. I think I just celebrated my 30th year of practice, so I have to make a little edit there. But so the constant though has been that I've always worked with individuals, couples, families, addressing their estate planning needs. And obviously that sort of spans dealing with the disposition of assets, doing that in a sort of tax efficient way, but also addressing issues such as incapacity, long-term care, and retirement planning. And I often partner with other professionals, including Chris, to make sure the estate plan fits in well with sort of a client's entire sort of financial profile. So I'll turn it back over to Chris.
Cool. Thanks, Andrew. So those of us that are on this presentation today have at least some probable background or knowledge of estate planning in general, and the need for the topic is obvious, right? Life is uncertain, and you want to make sure that your assets are protected, that your loved ones are protected, and that things move the way that you want. If you don't plan, things will be left to the rules of intestacy, and that means that the state, Massachusetts, if you live here, or some other jurisdiction, will decide who is your personal representative, who will inherit, who will be the guardian of your children. None of those things are good. So from our perspective, estate planning isn't just for the wealthy or older folk. We really do need to make sure that everyone has a core set of documents. And the core docs that we're going to get into right now are going to be things like wills, things that we refer to as living trusts or revocable trusts, kind of an interchangeable term, powers of attorney, advanced medical directives or healthcare proxies, HIPAA authorizations, and irrevocable trusts. So without further ado, let's talk about what a will is, Andrew. Let's get into the specifics of what that does and why one would need that.
Sure. So I think probably of all the documents here, if people had to name, if you said estate planning, what's the first document that pops into your head? People would probably say a will. But just one point before we even talk about what a will is, and this really revolves around what a will, is not, or what it doesn't do, which is that it does not handle the disposition of what we call non-probate property. It only handles the disposition of probate property. It can do some other things as well, but such an important point. I wanted to just really kind of kick off the conversation with this, which is that non-probate assets, which is for a lot of people is most, in some cases maybe all of what they have, do not pass under a will. Okay, so what are some examples? Retirement accounts, whether it be an IRA, 401k, 403b. So those will pass based on who the beneficiaries are. So you're married, you name your spouse as primary beneficiary, you've got children, your children as contingent or secondary beneficiaries. At your death, if your spouse survives you, the IRA, the 401k will be paid to him or her. If your spouse doesn't survive, you'll be passed, it'll go to your kids, okay? Another example of that, very similar, life insurance policies. When you buy the life insurance policy, they'll have you fill out a beneficiary designation form. Same thing. Those insurance proceeds at your death will be paid to the designated beneficiaries, okay? And then another big category of non-probate property, which again does not pass under the will, would be anything that's in joint names. So whether that be your home that you own jointly with your spouse, or a bank account, or a non-retirement investment account that's in joint names, either with a spouse, a child, somebody else. When one joint owner dies, by law, that account, that house, whatever it may be, will automatically pass to the survivor, not through the will. So I think there's a lot of sort of confusion or misconceptions on this point. So I just wanted to sort of emphasize that a bit. So
good stuff.
Put that to the side. Let's put that aside, and then let's focus on what the will does do, which is it basically does. There are three. We really focus on, I would say, 4 provisions in the will. Okay, 2 are related to assets. 2 are not. Okay, so typically in a will, we will say what happens to what we call your tangible personal property. So your personal possessions, whether that be jewelry, artwork, objects around the house, and we tend to separate that out and say where that goes. Okay, and there's sort of historical reasons for separating it out. I won't give people a history lesson today. And then everything else, and again, only probate assets. And again, there may not be any of these, okay? But any probate assets, the will say where those go, okay? In a simple will, you would just name, family members, friends, perhaps charities, where the property would go. In a pour over will, which is the type of will that goes along with a revocable or living trust, which we'll get to next, what the pour over will say is that the rest of the probate property, after we've dealt with the tangible personal property, the rest of the property gets added to the trust. And we'll get to that in a couple of minutes, okay? So those are the 2 things the will does relative to property, tangibles and everything else, okay? And the other 2 things that we do in the will is that's where you would name a personal representative of the estate. People are probably more familiar with the term executor, but about 10, maybe close to 15 years ago, Massachusetts adopted a new probate code and switched over from executor to the term personal representative. But this is the person that you put in charge of administering your estate at the time of your death, okay? And then the other thing that a will may do, if you have minor children, meaning at least in Massachusetts, under age 18, the will is where you would name a guardian or guardians for the children, if you die, before they reach the age of 18. Okay, so again, a will addresses 2 things relative to property, and 1 and perhaps 2 things if you have minor children relative to sort of naming people in some different roles. Okay, the will has to be written, can't or typed. Can't be an oral, or you can't just sort of declare it out loud. It has to be written down. Normally would be typed up by an attorney. You have to be at least 18 years of age. of sound mind, and there have to be two witnesses who also have to be at least age 18, and should not be people who are named in the will. It's also a good idea, not required, but a very, very good idea to have the will notarized. So, I mean, while it's not an absolute requirement, I would essentially consider it a requirement. So those are a little description of a will and some of the requirements. So Chris, why don't we, unless you got something to add, maybe we should move ahead to the.
So yeah, so I guess before we dive into the world of the revocable trusts here, let's talk for a minute about where people will use just traditional wills, where they might create trusts in them, what we'll call testamentary trusts, and where people would want to use these revocable trusts. So maybe we can come back to that. Let's talk about what the revocable trust is, and then we'll talk about where one would want to use it. Maybe that's probably a better way to go about it.
Okay, great. So a trust, before we get into living and revocable, but a trust in general is just a legal mechanism whereby one person, who we refer to as a trustee, holds and manages property on behalf of another person or persons who are the beneficiaries of the trust. Okay, simple as that. Okay, so then what do we mean by a living or revocable trust? So what we mean by that is it's a trust that somebody would set up during their lifetime, and they could put assets into their lifetime, but they don't have to. It could be that the assets don't go in there until the person dies. Okay, but as long as the person is alive, they reserve the right to, if they put assets in, they can take them back out. They can always change the trust. They can get rid of the trust. So that's sort of the revocable aspect of it. Okay, and we distinguish that from an irrevocable trust, by which once you put assets in there, you really can't get them back out yourself, and with some limited exceptions, really can't change the terms of it. So some of this is just sort of distinguishing it between revocable versus irrevocable. Okay, so pros and cons. Okay, so some of the pros of it are it's a way of again, if you fund it during your lifetime, or even if it gets funded after your death, you can you sort of have control over it, both directly, if you fund it during your lifetime, and you can still have control. But even after you've died, you still have control in that you've created the terms of what happens to the property after you're gone. So it's not direct control because you're not around anymore, but it's control based on the terms that you set up for the trust ahead of time. Okay? There's no sort of limit in terms of either too small or too big for a trust. I mean, it can be sort of any size estate. I mean, I would say we don't typically see them too much with really small estates, but sometimes even those situations, it actually does make some sense. Mm-hmm. It's a way of avoiding probate. Okay, so we talked a little bit before about probate versus non-probate, and gave some examples of non-probate assets. If you still, after looking through your list of assets, you still have some probate assets, one of the ways to avoid having to go through probate, because there cost and there's time period involved in probating a estate, one of the ways of avoiding it is, if you have a trust, or if you don't have one, you could create one. You can take those probate assets and during your lifetime retitle them in the name of your trust. Okay, so it's a way of avoiding probate. There are other ways as well, but this is one example of that. Okay, so it's obviously a way of planning for the future. If you fund your trust during your lifetime, you become incapacitated. It's a much easier way to sort of have somebody manage your assets on your behalf. We'll get into it a little bit, doing that through what's called a durable power of attorney. That's really helpful kind of for a shorter period of time, not necessarily over a longer period of time. Mm-hmm. A funded trust is a better way to go there. And I would say that maybe the final, and we could probably put more bullet points on here, but maybe the final sort of big pro of a living trust or advantage is it gives you the ability, particularly in a state like Massachusetts that has an estate tax and has a low exemption, a way of at least taking advantage of the estate tax exemption here, particularly if you're married. So you might be like, oh, this all sounds great, like sign me up right now. But just to be aware that there are costs involved. I mean, a plan that includes a living or revocable trust is going to be more involved and by definition sort of more expensive to set up than one that doesn't involve trust, where if you just did a simple will. It does require some sort of dotting the I's and crossing the T's, particularly if you want to either make sure it's funded during your lifetime or to make sure that the assets you want to get into the trust at your death in fact get there. So it's a little more expensive, a little bit more complicated. Is it worth it? I would say for most people it is, but it's not necessarily for everybody. You have to have that conversation with your attorney, with your other advisors, and make sure that the trust makes sense for you. I mean, it's not for everyone, but I would say it does make sense for the vast majority of people.
Sure, and I would agree. From my perspective, I just think having assets in the trust and funding the trust is so critical from a perspective of just simple control. And I've had many clients that have become incapacitated in their later ages, and having assets fully funded in the trust was tremendously helpful to be able to have a trustee simply manage it. As Andrew indicated, the other option will be, in a moment, we'll just look at the powers of attorney and look at a durable power of attorney. The reality is that if you go into a bank or a financial institution with a durable power of attorney, they're going to put it under the microscope, and their default mechanism is to traditionally try to avoid using it and acknowledging it. But for whatever reason, if you show up as the trustee of a trust, the red carpet's rolled out, and they tend to want to work with you and not give you any grief. So just from an ease of use and just in case sort of thing, I think having a funded Rev Trust is really, really important. And do you want to spend a second, Andrew, and talk about the mass estate tax exemption being?
I will do that. I just want to make two other quick points, then I'll jump in. So one is that a lot of people wonder if you fund a revocable trust during your lifetime, do you have to get a separate tax ID number for it? And the answer is no. You would just use your Social Security number. So to the extent that you're generating, income, things like that, it's going to still show up directly on your own tax return. So it's not any more complicated from an income tax standpoint. And the other thing, and this ties into the Massachusetts estate tax, which is that simply putting assets in a trust doesn't in and of itself save you estate tax. It's being able to take advantage of the estate tax exemption at your death. So it's not like you can put all your assets in a revocable trust and suddenly you have nothing in your estate for tax purposes anymore. It doesn't work that way. So just wanted to clarify those points. But then getting, as Chris said, to the Massachusetts estate tax. So right now Massachusetts is arguably we're tied with Oregon in terms of from a estate tax standpoint, the worst place to die in the country. So there's only about 15 states that have a separate state estate tax. There's a federal estate tax, but then only about 15 states have a separate state estate tax. And among those 15, Massachusetts is tied with Oregon and having the lowest exemption, which is $1 million. And to make matters worse, it's not really an exemption, because if your taxable estate is more than $1 million, you actually get taxed on every dollar, not just the dollars over $1 million. So if your estate is $1,001,001, you're going to pay something like $25,000 in mass estate tax. That $1 will cost you $25,000. If your estate is exactly $1 million, the tax goes down to zero. Okay, but again, the key term there is taxable estate. Okay, so for a married couple, at the first death, let's say the first spouse dies and they have $2 million in their estate. Okay, if that entire $2 million is going to their spouse, there will be no estate tax, because the $2 million will be reduced by a $2 million deduction. The taxable estate will be zero. Okay, and let's just for argument's sake say that the surviving spouse in that example, she or he has his or her own $2 million. Okay, so they inherit $2 million at the first death. At the second death, they've got their own $2 million as well. So there's a total of $4 million. Okay, because $4 million is more than $1 million, and there's no spouse at that point to get a deduction for, because now we're talking the second death. The taxable estate will be $4 million, and the estate tax will be computed on the entire $4 million. Okay, and that tax liability will be roughly $300,000. Okay, if instead, and so we haven't taken advantage of any $1 million exemption, deduction, whatever you want to call it. Okay, if instead at the first death, instead of the $2 million all going to the surviving spouse, if we have $1 million go to the surviving spouse and the other $1 million go into a trust, which again would be part of this revocable trust plan, the other $1 million be held in trust for the benefit of the surviving spouse. Okay, there still will be no estate tax at the first death because we get a $1 million marital deduction. And then the other $1 million that goes into the trust, that takes advantage of that $1 million exemption. Okay, so no estate tax at the first death. And at the second death, the estate tax will be computed on $3 million, not $4, because the $1 million that's in the trust, even though the surviving spouse will have access to it, they will not be taxed on it. So now we're computing estate tax on $3 million, not $4 million, and we would save roughly about $100,000 in estate tax. Okay, but again, the trust has to be set up before the first spouse dies. It can't be set up after the second. Okay, so again, unfortunately, if you're not married and your taxable estate is more than $1 million, you're kind of out of luck when it comes to that exemption. Now,
time to move.
Yeah, sorry, go ahead, Chris.
I was going to say it's time to move.
Yeah, so there was. The legislature of Massachusetts got very close earlier this year to passing a law which would have increased the exemption from 1 million to 2 and made it a true exemption. And what I mean by that is it wouldn't have been this thing where if you're over $1 million, you pay tax on every dollar. So for a married couple, it actually would have increased the true exemption from 1 million to 4. And even for an unmarried person, it would have given them a true $2 million exemption. So it would have been a real game changer from my perspective. Unfortunately, it didn't pass. We thought they might revisit it last month. They kind of passed on it again. Maybe it'll come back into the conversation maybe next year, year after. Stay tuned on that. But for the time being, Massachusetts remains at the bottom of the list for worst places to die. So just be aware of that. So let's switch topics here. Enough about taxes. Let's turn to planning for incapacity. Okay, so this really falls into sort of two categories. So sort of the financial aspects of that and the sort of medical health care decision aspects of it. Okay, and the context is you're in an accident, you get very sick. Maybe later in life you develop, dementia, things like that. And there's a period of time, it could be a week, could be a month, could be, years where you need someone to take over sort of decision making for you. Okay. So on the financial side, so to make sure that your bills are getting paid, that your tax returns are getting filed, that a business you're involved in, that decisions are being made there, what you want to have in place is what's called a power of attorney. And sort of the gold standard here is what we would call a durable power of attorney. Ordinarily, a power of attorney, if you become incapacitated, the power of attorney ceases to be valid. Okay, so obviously the idea here is that we want this to work when you have become incapacitated. So that's the durable aspect of it. Okay, so you're going to want to name a primary person and at least one backup. And again, just people who you trust, people who are good at kind of dotting the I's, crossing the T's, will make sure that those things are happening. Your bills are getting paid, your tax returns are getting filed. Okay. So if you're just while we're on the topic of power of attorney, sometimes you might name a power of attorney, if you're maybe closing on a refinancing, something like that. You don't want to have to bother going, to the office where it's happening. Maybe you name you grant either a limited or something that's called a special power of attorney, just so somebody can act on your behalf for that sort of transaction. But again, the gold standard for kind of dealing with incapacity is what's called a durable power of attorney. Okay, so that's on the financial side. Switching gears onto the healthcare or medical side, and Chris, yeah, there we go. Sometimes a little bit of confusion here in terms of what these documents are called, but at least in Massachusetts, the document that you absolutely have to have is what's called a healthcare proxy. Okay, created by statute in Massachusetts, so no question about its validity. So it's a document in which it's very simple. It's just a document in which you say that if you're unable to communicate your wishes regarding your medical care, your health care, okay, that you designate somebody to be your voice, to be your spokesperson, okay? And again, just like in the power of attorney, you want to have a primary and at least one backup, because maybe your primary isn't available either, okay? Maybe they were in the same accident you were in, okay? So again, primary backup, okay? So you definitely want to have that. Another document that you really want to have is what's called a HIPAA release, okay? The HIPAA release is just giving doctors, nurses, etc., permission ahead of time to share your personal medical information with someone serving as your healthcare agent. So the document is a healthcare proxy. The people you name in are referred to as your healthcare agent. The HIPAA release, which I do as a separate document, some attorneys combine the healthcare proxy and the HIPAA release together. Mm-hmm. The HIPAA release just says that it's okay for those medical providers to share your personal medical information with your healthcare agent, because obviously if they're making decisions for you, they need to have all the information available to them. Okay?
Would be good.
Yeah, so those two documents I would consider like absolute, like you have to have them, okay? Now, what you might want to have, but I would say don't have to have, is what's sometimes referred to as a living will or advanced healthcare directive, where you put down in writing your wishes regarding healthcare decisions on your behalf, and in particular, perhaps end-of-life decision-making, okay? So if you have strong wishes about that and you're comfortable putting those in writing, by all means, draw up whether you can call it whatever you want, doesn't matter. There's no statute in Massachusetts that governs it, so you can call it whatever you want. But if you want to put those wishes down in writing, great. If you don't want to do that, or even if you do that but want to add to it, it's also a really good idea to have a conversation or conversations with the people you've designated as your healthcare agent and let them know how you feel about that. I mean, I think black and white only goes so far. I think the conversation really sort of provides the color, really provides maybe, kind of some of the things that are a little bit harder to express in writing. So
and
again,
I would also chime in there, Andrew, that's great advice and something that many people don't do enough of. But if we just harken back to, the basic document, the will, more often than not, the will isn't going to describe what your wishes are relative to your funeral, your services, where you're going to be buried, if you'll be buried, shall you be cremated, so on and so forth. So those are important conversations to have with your personal representative well in advance, so that they know what your objectives were and what you were looking for, and you're not going to be leaving them in the lurch to make those important decisions at a time when they're going to be grieving. So I think communication is really key.
No, and these are not easy conversations to have, but they're important ones, and specifically on the healthcare side, there's a great resource out there, something called the Conversation Project. I believe that the web address is theconversationproject.org. So I would encourage you to take a look at that site, and there's some great resources on it. So almost 12:30, so let's
we're just gonna we'll plow through the rest of this real quick. There are a couple of questions.
We've kind of touched on I would say the core kind of documents and issues. So these maybe are a little bit more kind of a la carte items, so we won't spend as much time. But I mentioned earlier, kind of differentiated revocable from irrevocable trusts. So irrevocable trust, I would say they tend to be used in a couple of contexts. One are for people who are sort of particularly concerned about estate tax. Maybe they sort of have an estate where they may even be subject to federal estate tax, so they're really trying to kind of get that taxable estate down. So they may transfer assets during their lifetime to kind of reduce the size of the estate. And then the other context is it sometimes can be used to help with long-term care planning to help you qualify for Medicaid, or in Massachusetts, what we call mass health. I would say the on the tax side, the asset that we probably 90% of the time see people put into irrevocable trust are life insurance policies. And the reason is that while you're alive, a life insurance policy typically isn't doing much for you. If it's a term policy, it's really doing zero for you, other than giving you some peace of mind. So it's the kind of asset that most people, they're okay giving up ownership of it because it's not doing anything for them anyway. But life insurance is includable in your estate for estate tax purposes if you own it. But if you don't own it, it's not taxable. So that's probably what we, again, 90% of the time, that's what people who create irrevocable trust, that's what they're putting into them. Okay.
There you go.
So there's maybe a minute on irrevocable trust. We could spend probably a whole day or more on it.
Certainly could.
Prenuptial agreements. If you're thinking of getting married, maybe you've got kids who are heading in that direction. Obviously it doesn't sound sort of too romantic. Kind of people hear that and they're like, really? Like, why would you want to do that? Really, the idea here is, nobody should be doing this because they're expecting to get divorced. The idea is that, you're entering into a relationship, think of it in some ways as like a business relationship. Would you enter into a business relationship without having an agreement that says if things don't work out, here's how we're going to kind of unwind things? So it's the same idea. It's like, we're not expecting to use this, but if things don't work out, rather than have to spend a whole bunch of time and money at the time figuring it out, let's just figure it out ahead of time, put it down on paper, get it signed, and hopefully this thing will never ever see the light of day again. But if we need it, it'll be there. It'll make what is going to be a terrible situation much easier, because we will have already negotiated how things are going to play out. So prenuptial agreement, it's going to deal with what happens to the assets, including what happens in the event of even short of divorce. If somebody just dies during the marriage, do you want to maybe spell out some rules regarding that? So it talks about how assets are dealt with during the marriage, deal with debts. Maybe one spouse is bringing debt into the marriage, the other one isn't, so they want to deal with how we how that's addressed. When to include lawyers? Obviously, I'm a little bit biased here, but the truth is
all the time, right?
Yeah, and the truth is, there's if you want your prenuptial agreement to stand up, I mean, obviously your goal is that it not be necessary at all. But if you don't want to spend the time and effort putting one together only at the time of divorce to find that it is actually invalid. And
correct.
One of the ways to ensure its validity is to include lawyers, and there has to be a lawyer on each side. Okay, one lawyer can't represent both parties. One lawyer can take the lead, do the initial draft, bring in the other lawyer to have them review it on behalf of the other party. But there needs to be lawyers involved. There needs to be full disclosure of assets, and also you can't sign a prenup, the night before the wedding. Like, you want to start this process, I would say, 6 months before the marriage, and with an eye to getting it signed at a minimum, I would say a month before. Ideally, maybe even earlier, but this isn't something you want to be, signing while you're, straightening your bow tie on the morning of the wedding. So
that's for sure. That is for sure.
So,
so here we are. We're going to just kind of wrap up. This is my contact information. As I said, Chris Cahill. If you're looking for me, it's chris@12pointswealth.com, or even easier, 12points.com. Need to update that. And more importantly, Andrew's contact information, abutler@archstonelaw.com, down here. Andrew, again, thank you so much. We do have 2 real quick questions, so I'm going to just kind of get these over to you. Somebody asked, what happens if you put your house in trust and then decide to sell it?
So not a problem at all. You know, as I was saying earlier, a revocable trust is really still just an extension of you, uses your social security number. So, you know, it might make, you know, a little bit of the paperwork at the closing, you know, slightly, you know, might be an extra form or two that you get that big stack of papers. Maybe there's an extra couple there related to the trust, but yeah, not an issue. Still qualify for the capital gains exclusion, either $250,000 or $500,000, depending whether you're single or married. So yeah, you know, that's fine. I mean, that said, if you're married, I'm not a big fan of putting your primary residence into a trust. I would say that, and I used this term earlier, really the gold standard for home ownership in Massachusetts for a married couple is what's called tenants by the entirety, which is just a special form of joint ownership for a married couple. So I wouldn't rush to put in a trust if you're married. If you're single, you know, it definitely can help with the avoiding probate, but be aware that putting into a trust, it's not free. You've got to have a deed prepared, what's called a trustee certificate, pay some recording fees. So think about whether it's actually worth the cost and effort. So, and then it was one more question, Chris.
Yeah, and the last one here is: would it ever make sense to have a trust account be the beneficiary of a 401k or IRA? And this is obviously a complex and loaded question, but love to hear your initial thoughts on it here as we wrap up.
I would, you know, this will sound like the classic, you know, lawyer answer, which is that it depends. It definitely is. It makes things more complicated, and the trust has to have some very specific language in it. So you want to make sure if you're going to go that route that you're working with an attorney who has experience with that. You know, let's just put it this way: retirement accounts and trusts don't go so well together. So you know, it has to really, you know, be worthwhile. But in some situations, it really does make a lot of sense. But you just want to make sure that you're working with both a lawyer on the legal side and with a, you know, sort of financial advisor on the side of like the investment itself to make sure that everything's sort of done properly. Because if you don't do it exactly right, there can be some pretty nasty consequences. So so you know, if you're going to go that route, just be careful. So
wonderful. Well, again, thank you, Andrew, for your time. We've hit the 38-minute mark here, and well done. And as always, appreciate your expertise and assistance here. And if you have any questions that you'd like to run past Andrew, you've got his information here. Certainly, again, if you're looking for any information from me, Christopher Cahill, 12 Points Wealth. And thanks again. And I hope everyone has a wonderful Thanksgiving. Talk to you soon.
yeah, thanks, Chris, and happy Thanksgiving, everyone.
Bye-bye.